Hello and welcome to this week's episode of Chaile Time. Toby, welcome.
Hello, Chepo. How are you doing?
I'm good. And how are you?
I'm very well. We busy revamping Chaile Time. So what people can't see is some of the furniture and the stuff we have bought so far, and hopefully in the next 4 weeks we're going to rebrand completely. So it's going to be a whole new Chaile Time.
At least Effectus has got budget.
Eh?
Unlike...
We don't need the DA to tell us that, we need to go back to the drawing board.
At least you have budget. Okay. So what have you been busy with?
Well, we've been busy. I've been very busy this week with retrenchments. There's a lot of those kind of cases. Okay. And very interesting CCMA case yesterday.
Okay, is that what you're going to talk about today?
We're going to talk today about the CCMA indeed having jurisdiction and the powers to determine whether a separation agreement, these mutual separation agreements, whether it was signed under duress or not. And effectively, if it was, to declare it null and voided, to listen or arbitrate the underlying fairness of that termination.
Before you go further,
is
there something that is called a voluntarily separation agreement?
Yeah, that's what we're talking about.
And then there is a mutual separation agreement. Is there a difference between the two?
No, it's the same thing.
Or it's just the use of terminology?
It's just the use of terminology.
Okay.
I know with this is not really a matter of law, but typically you'll find if a mutual separation was done in the context of a retrenchment, a Section 189 process, then it's typically called a voluntary severance agreement or so, or separation agreement, and all other separation agreements is typically called a mutual separation agreement. But I see these days what people do is they don't call it VSP or MSA, they just do it as a settlement agreement. I see that's like a thing now at the moment,
So, worst case scenario now. There we are, employee agrees to everything that you say, you sign, and then everything goes according to plan. Then you are happy that, okay, we separated mutually, we are agreeing on the terms and conditions and everything. Then boom, 3 weeks down the line, you get a 7-11, and then you get someone to the CCMA to say, no, the employee is not happy, they say they signed under duress, or you didn't give some sort of an ex gratia. So, is that now what you want to clarify, what you want to tell our audience about?
Yeah, this is the thing. I dealt with a case yesterday whereby a mutual separation agreement was indeed entered into between the employer and the employee. And interesting is, while we were sitting in reception, the HR executive told, no, but this should be a walk in the park, I mean, there's a contractual agreement in place, They spoke to their company lawyer, and the CCMA don't have jurisdiction to deal with these matters, And I'm like, that lawyer probably doesn't specialize in labor. It's probably a criminal lawyer or something like that, because life changed, Now, where this notion comes from, or how it was enforced also is in the labor court case, First National Bank versus Moy, where the court basically stated that, to determine the validity of a contract or an agreement, is normally the prerogative of the courts,
Yes.
not necessarily the CCMA. So, and for a very long time, CCMA commissioners, they will very easily reject a dismissal dispute if there was an agreement entered into between the parties to separate ways, because normally you can determine your own grounds of how do you want to deal with a dispute in the workplace. And also there's this constitutional court case, Muyuwa Ngbenga Olu Watowe versus Rekket Benkeser, South Africa. And this is a constitutional court case, and this court case basically upheld the notion that parties must be entitled to decide on themselves how they're going to resolve a dispute, especially in context of a separation agreement. And I just want to read this paragraph here. The public and indeed our courts have a powerful interest in enforcing agreements of this sort. The applicant must be held bound by this agreement. When parties settle an existing dispute in full and final settlement, none should be lightly released from an undertaking seriously and willingly embraced. This is particularly so if the agreement was, as here, for the benefit of the party seeking to escape the consequences of his own conduct. Even if the clause excluding access to courts were on its own invalid and unenforceable, the applicant must still fail. This is because he concluded an enforceable agreement that finally settled the dispute with his employer. Now, I'm not going to go into too much detail in this case, but there is something I do want to mention. Section 34 of the Constitution provides that people have the right to approach a court for redress.
Yes.
They have to be subjected to a fair hearing. So there's some argument, about these agreements. Inside it, there's a clause in there that says that if you sign this agreement, it will be in full and final settlement of this matter, which means the employee, in essence, cannot sue the employer at the CCMA or the courts. It's a limitation clause. So there's some argument as to whether these limitation clauses, whether it is constitutional or not, given Section 34 of the Constitution. But now here the court is saying, regardless of whether it's reasonable or not, or legal or not, there's the second element to a settlement or a separation agreement. That's the fact that you actually tried willingly to actually settle the matter.
Yeah.
Regardless of whether it is in full and final settlement or not. Here you have two parties. There's a misconduct that happened in the workplace, and they both agree to deal with this matter, and they settled the matter. Now, normally, you will have the agreement from a monetary perspective. You will have your statutory payments, like your pay, maybe notice pay, leave pay. And then there's typically an ex gratia payment, which is something extra, negotiated between the parties. And in turn, the employee will agree to a full and final settlement. But now, in this case, the employee actually challenged that and said, but listen, it's unconstitutional. And then the court basically said, listen, we're not going to enter into that debate now, whether it is constitutional to have that kind of clause. But be that as it may, you still agreed in terms of the underlying, dispute and how to settle the dispute. So
Yes.
the courts held, or this court basically held, the importance of keeping parties bound to an agreement. But Tsepo, now in this case of ours, this is now where the pawpaw hits the fan.
That's where I wanted to ask you now a quick question. Now, in your case that you were dealing with, was the employer ticking all the boxes?
Well,
In your view, were all the boxes ticked?
before I go to the boxes tick, it's a very important question you're asking.
Yeah.
And I want to answer all of that because there's a lot to be said here, okay? But I just want to leave or start with a bit of a legal context here, legal framework.
Okay.
So I dealt with the Constitution. So on the one hand, these agreements, mustn't easily be parted with. If there's agreement in place, it must be upheld. But now you get the Cooks for Life case with the Labour Court. And here, and I'm going to read this provision now, but here the court is saying, but listen, in terms of Section 191 of the Labour Relations Act, a commissioner must determine whether there's an existence of a dismissal. And I'm talking specifically about an unfair dismissal dispute now. A commissioner must make a determination whether there's a dismissal in line with Section 186, subsection 1 of the LRA. Okay? So now the court is saying, but listen, how can you now say a commissioner can determine the validity of a separation agreement, but the law requires him to determine the dismissal. So the court is saying, but listen, there's this issue of jurisdiction and power. In short, the court said, listen, of course the commissioner indeed has the power and the jurisdiction to determine whether, and most of the time, the challenge of the employee is based on signing an agreement like that under duress. Indeed, the CCMA does have the powers to determine whether that contract was signed under duress or not. And if it was found that it was indeed signed under duress, they are within their authority, in their powers, to actually declare it null and void, and then to continue proceed to determine the underlying procedural and substantive fairness of the actual dispute itself. Let me just read that provision. So here's a Labour Court judge. In my view, the refusal by commissioners to enter into any consideration of the validity of an agreement confuses the concepts of jurisdiction and power. The CCMA has jurisdiction to determine unfair dismissal disputes, and it is specifically enjoined in terms of section 115(1)(b) to arbitrate disputes referred to it after a failed conciliation. Section 191 contemplates that the CCMA must make a ruling when the existence of a dismissal is placed in issue by determining whether or not an employee referring an unfair dismissal claim was dismissed within the meaning accorded to the term by Section 186, subsection 1 of the Act. That's now the Labour Relations Act. That being so, I fail to appreciate why, in matters such as the present, when it is contended that an agreement is voidable on account of it having been induced by duress, the CCMA is not empowered to make that determination in the exercise of its jurisdiction to determine the existence or otherwise of a dismissal. To require an applicant in those circumstances to refer a contractual dispute to this court, now the Labour Court, as a precondition to arbitration on an unfair dismissal claim would defeat the statutory purpose of informal and expeditious dispute resolution and would import a requirement that finds no reflection in the Act. So there you have it basically. There's no point in claiming the person must go to the Labour Court because of a jurisdictional issue. The CCMA can determine duress. Now, Tsepa, to come back to your question. What's your question again?
My question is, in your case that you dealt with, did you tick all the boxes? As the employer, of course. Now.
Well, the starting off point is, and I've spoken to some of my colleagues in other labour law firms, and so they don't necessarily agree with me. Now, I understand that employment relations are very dynamic and employers often don't want to pay a lot of money. I'm from the school of thought that believe that if you enter into a separation agreement, you need to do an ex gratia payment. Now, I understand it's not a legal requirement that you must do so. I mean, I suppose you can just agree on terms and conditions, basically in terms of your statutory payments, what's owed to you, whatever the case may be. But as I have studied, Labour Court judgments over time, I come to realize that, to really strengthen the enforceability of that agreement, you need to pay something extra, especially with this contentious issue of being full and final settlement. That full and final settlement, in one way of interpreting it, is actually in breach of Section 34 of the Constitution. But keeping in mind, the courts are basically saying, look, okay, it seems like it's allowed, okay? And, also at the CCMA, they seem to uphold it, okay? But what they typically look for is that extra mullah, you see, that extra benefit. There's, I think it is the Cooks for Life case, the actual CCMA case. The commissioner said, listen, you guys settled on statutory payments only. So there's a massive benefit for the employer. The employee can't go to the CCMA, but there's no benefit for the employee. One school of thought will say, yeah, but okay, he's still settled on the fact that there's no dismissal on his record. Okay, I hear you. I think in a way I actually agree, but okay. The fact of the matter is there's a provision in there that says no CCMA. And the courts sort of seem to endorse the concept that there must be some extra money there. So in this case now with ours, there's nothing like that. Okay, so, or I can't say nothing like that. The employer did pay an extra bonus. But here's now the thing, Tsepo. Now I walked in there yesterday. The termination was done around about the middle of a certain month. The employee was paid until month end, and an additional bonus was given. So it seems like he was paid for his normal pay up to the middle of the month, okay, and then there was an extra ex gratia bonus being paid. But at CCMA sometimes they throw these curveballs, So I come there. And here's the employee, Mr. No, she's not represented. No? She's like, Mr. Commissioner, I don't understand this. Here they say, I got an extra payment. But all the payments add up together and on the payslip is exactly the same amount as my letter of offer. My letter of offer's got the basic pay and my travel allowance and all these kind of things. So it seems like they just reworded the travel allowance to call it bonus. So the money on my letter of offer is the same as the money on the payslip. Yeah, like I'm sitting there, oh yeah, and now she's challenging the underlying fairness of the dismissal. Yes. She's saying she was dismissed. Now, actually, I'm actually pretty confident in the underlying fairness of the dismissal. She didn't perform well. Yeah. And there was performance reviews done, and clearly she didn't perform well. So I'm actually not, I'm very confident in, she had to dismiss her.
And you said she stated that her probation was going to be extended.
Well, one thing in arbitration, don't be a dishonest witness. Yeah. Because you're going to lose the confidence. Commissioners are trained to look at your eyes and your demeanor. Because remember, in essence, often you sit with two opposing versions. How must they decide? One of the skills they have is to look at your demeanor and whether you appear to be a witness of reputation and integrity or so, okay? If you start lying, it's a big thing, no? So this employee started by saying, look, I'm performing very well. The company's told me I'm performing very well. But Mr. Commissioner, they even extended my probation. Yeah, here's a letter. They extended my probation. I'm like, she doesn't know what it means. But anyway, okay, so yes, the company did extend the probation. And, Mr. Commissioner, even though they extended my probation, they still were talking about putting me in a hearing. I don't understand. I was performing so well. So eventually when the commissioner gave me the opportunity, I said, Mr. Commissioner, here's the bundle of documents. There's a performance review. She signed it. And she clearly, of all the targets, she didn't meet the target. She only did something about one of the KPIs. Yeah. She was completely underperforming and she was in probation still. Okay? The commissioner looked at her and said, listen, this letter, you signed it. This is the performance review. Yeah, no, I signed it. You see here it says, I agree, I was explaining the full contents of this letter and that if I don't improve my performance, I may be dismissed. Yeah. Mr. Commissioner, it's actually the first time I see that. Yeah. And then I said, but listen, Mr. Commissioner, just by the way, also, I don't think you understand what it means if they want to extend the probation. It means you're not performing, honey.
Because we're going to get permanently employed.
And look, she received a permanent contract, but on probation for 3 months. And you're saying they wanted to put you in a hearing. You didn't perform. Okay? And that now, then they said, no, hold on, we are going to enter into a mutual separation agreement. But now I'm sitting here with the issue of the money. Yeah. So there's technically no ex gratia additional payments here. That makes me personally feel a bit uncomfortable. But okay, luckily I was quite quick to pull a rabbit out of the hat there. I showed it, because now she says she fails to understand the extra money part. So I said, Mr. Commissioner, can I explain it to her? So he said yes. I said, listen.
Sunshine?
No, I didn't say sunshine. I normally think that, you see. So I said, listen, you see this settlement agreement, the separation agreement. You were terminated. This was signed and you were terminated in the middle of the month. Okay? That means if you were dismissed, your payment would have been up to that moment.
But you were paid up until the last day.
But you were paid in the last day. So you were supposed to get half your salary. You actually got double. So there's additional payment in there. So whether your payment you receive is the same as your letter of offer, the fact of the matter is now you got a 50% additional payment. But Tsepo, so from that perspective, so the commissioner now has got 14 days, he's going to make a ruling on whether he's got jurisdiction or not. And that's the point of today's Chaile time. That just the fact that you signed a separation agreement, that doesn't mean you cannot go to arbitration unprepared, because that's not going to mean the commissioner is going to throw it out. But there's a second issue I just want to touch base on. Once again, the issue of the importance of an employee being represented, because they say things, they do things they shouldn't do. Now, in this case, as far as the payment is concerned, the separation agreement actually states there we're not going to pay your leave out because this was in December, so there's a shutdown period. Okay? So in essence what it means is the reason why she was terminated in the middle of the month is because the rest of the month is actually a leave. So they're not paying out part of the payment therefore obviously is now a leave. So I'm sitting there and thinking to myself, so this other 50% or whatever is obviously a leave paid out. So she actually does have a point. But now because she doesn't have somebody who's representing her, she never raised that. She never addressed that. The commissioner never addressed that. I obviously did not address that. I kept quiet. I'm like keeping quiet. Because if she said, no, but hold on, this extra payment, here in the contract or in the agreement it says it's my leave.
So I guess this is where it comes, where I say, everywhere, even criminal law, everywhere. You remember the O.J. Simpson case? Mm-hmm. Some cases are won with technicalities.
It's technicalities.
Not really substance and other things, but technicalities.
Yeah, and this is the thing, where she represented, they would pick up on that. But now, I wasn't too concerned, other than, if you don't word a contract correctly, it can messes up a case, okay? The reality of the matter is the company didn't owe her leave. That she was actually a negative balancer. So she actually owed the company. But now, if she was represented, they would have opened that closet. Then it would have been difficult to really now convince the commissioner, but they've actually made typing errors in the agreement. It shouldn't have been like that. And yes, then it is uncharted territory, Then you don't know what the commissioner is going to do. But I'm just saying, these technicalities, and also when it comes to the duress part, she stated that when the operations manager negotiated or spoke to her about the mutual separation agreement, they at one stage phoned the HR manager on speakerphone, and the HR manager said, but listen, she said, if I'm not signing, they're going to delay a payment. And also she'll go in hearing and they'll fire her. So that is where the duress part is coming from. Then I just said, but listen, I didn't agree with you. I actually have that person right here sitting outside to come and testify. When I interviewed her, she was like completely surprised because she said she didn't even speak to you on that day. She didn't engage with you whatsoever. But this is now the thing. Then she said, if that is what she's saying, she's denying it, I'm fine with that. I'm like, if you were represented, he would have coached you to tell you, you don't say things like that. What does the commissioner now believe? Because you're already lying about the performance part. Now it's, if that's her view, that's okay.
So,
and we had a Chaile come the other day, the employee will say, this is what happened. Yes. When you speak to the employer, they say, it's not so. It's like, who do you believe?
Then you don't know.
Everybody seems to be so honest,
So what I'm saying is, now, in our audience, who this episode is going to add value on whose side, actually, more? Who must
I think in terms of the main point I made with the settlement agreements or the separation agreement, that just the fact that you sign a separation agreement does not mean you can go to the CCMA, waive the agreement there, the commissioner say you don't have jurisdiction. That is of value for employers. Look, it's of value for everyone. It's important employees also know that if you did indeed sign an agreement under duress, it doesn't mean you can't go to the CCMA. But especially for employers, some employers sign malicious agreements thinking, there's no CCMA. No, those days are gone. Okay. But secondly, also the part with representation. It's important, This is where, for instance, companies like Clientele Legal. I don't know what their fees are. I think it's like 200 Rand or something like that a month. If you can afford it, get them on your side, man. It's nice walking in there, with a representative or whatever. Or, if there's a union in the workplace, be represented. Maybe if there is a union in the workplace, maybe join the union. It's nice to walk into CCMA with somebody, Okay, or get yourself a lawyer.
Okay, is that all for us for this week?
That's for this week, yeah.
Okay, thank you for watching. Don't forget to like and subscribe.
I must advertise. Sorry. Yeah, you must subscribe, man. The Harmony People Network Conference, HR conference, the most popular, the wildest HR conference in South Africa every year. Gifts for everyone that attend. 5th and the 6th of August in Gauteng. Don't miss that one.
2025.
Yes,
Forgot to say
2025.
This year, not 2026. This year.
It will be on 2026 also. I don't know what date still. That will be then too.
Okay. Thank you for watching. See you next time.
Bye.
Bye.